To keep yourself updated, subscribe to Indigolearn and click the bell icon and download our app OneFin to start learning on the go.
Let's quickly summarize what we have understood and what we have discussed in Unit 1 of the Indian Contract Act. So we started with some basic terms. We've understood what is a contract. Contract is an agreement which is enforceable by law. And we've also understood what is an agreement. Agreement is every promise or set of promises forming consideration for each other is nothing but an agreement. And we have also understood what is a promise. Promise is when a person to whom the proposal is made signifies his assent to that proposal. The proposal is said to be accepted, and accepted proposal is a promise. So we have understood these three basic terms, and we also have three equations with us. Offer plus acceptance is equal to promise. Promise plus consideration is equal to agreement, and agreement plus enforceability by law is equal to contract. After this, we have understood what are the differences between an agreement and a contract. So agreement is defined in section 2 clause E of the Indian Contract Act as promise or set of promises forming consideration for each other, whereas contract is defined in 2 clause H, which says it is an agreement which is enforceable by law. Agreement includes all social and domestic type of agreements as well. Legal as well as social agreements are included in agreement, but contract includes only those agreements which are legally enforceable. And we've also understood that all agreements are not contracts, but all contracts are agreements. After this, we have understood what are the essential elements of a valid contract. Now, regarding these essential elements, they were divided into two categories. One, the general essential elements, and other given to us by section 10 of the Indian Contract Act. And in all, we have 11 essential elements of a valid contract. The general essential elements were two parties. There has to be two parties. We have seen a case law for this, State of Gujarat versus Ramanlal and Company. The second essential element was parties must intend to create a legal relationship. Again, here we've seen a case law, and the case law here was Balfour versus Balfour. The next essential element was certainty of meaning, possibility of performance, and in certain situations, some other formalities have to be fulfilled. Then we have seen essential elements which have been given in section 10. And what is the statement of section 10? All agreements are contract if they are made by free consent of parties competent to contract for a lawful consideration and with a lawful object, and which are not expressly declared to be void. So what are the essential elements as per section 10? There has to be an agreement. Free consent of parties is important. The person entering into contract should be capable of entering into contract. Capacity of parties to enter into contract, and who are capable? A person who is a major, a person of sound mind. He should be a person who has attained the age of majority, a person of sound mind, and should not be disqualified by law. The next essential element was lawful consideration, then lawful object, and it should not be expressly declared as void. So these were all the essential elements of valid contract which we have understood. After this, we have discussed what are the different types of contract. On the basis of validity, we have understood there is a valid contract. A contract which contains all the essential elements of valid contract present in it is a valid contract. Then we have understood what is a void contract. So void contract is one which ceases to be enforceable by law. It may be valid in the beginning, but later on, due to happening of certain circumstance, later on due to happening of any event or change in the circumstances, the contract may become void. And if a contract is void since the beginning, it is called as void ab initio. Then we have understood what is a voidable contract. So this is a contract which usually comes into existence when consent of the party is not free, when consent of one of the party is not free. and avoidable contract is a contract which is enforceable at the option of the aggrieved party, which means the party whose consent is not free has an option either to avoid the contract or continue with the contract. After this, we have understood what are illegal contracts. Illegal contracts are contracts which are forbidden by law. Then unenforceable contract. Unenforceable contracts are contracts which are good in substance, but there is some technical defect in the contract. After this, we have understood the types of contract on the basis of their formation. The first type was express contract. Express contracts are contracts where the terms of the contracts are expressed by words spoken or written. So it can either be orally, verbally agreed upon or expressly written. The second type of contract was an implied contract, which is implied by actions of the parties or implied by law. Implied contracts have a subtype, and that is a tacit contract. Tacit contract is a contract which is implied by actions of the parties without any words spoken or written. The next type of contract which we have understood is a quasi-contract. So this is not actually a contract, but there is an obligation which is imposed by law, and that the obligation which is imposed becomes a quasi-contract. And then we have understood what are e-contracts. So these are the contracts which are entered into using electronic means. After this, we have understood the types of contract on the basis of performance. So on the basis of performance, there are two types. One is executed contract and the other is executory contract. Executed contract, where the parties to the contract have already performed their respective obligations, we call that contract as an executed contract. And executory contract, it is a contract where the parties to the contract are yet to perform their respective obligations. Executory is further divided into unilateral contract and bilateral contract. Unilateral is where one party has performed their respective obligation but the other party is yet to perform, and bilateral is where both the parties are yet to perform their obligations either in full or in part. After discussing types of contract, we have understood what is an offer. So what is an offer? When a person signifies his willingness to do something or not to do something with an intention to obtain the assent of the other party, we said that he is making an offer. And there are different types of offer. First one was general offer. An offer which is made to public at large is a general offer. Who has the knowledge of the offer can accept it. We have also seen a case law here, Carlyle versus Carbolic Smokeball Company. Then we have understood what is a specific offer. The specific offer is one which is made to a specific person, and the case law here was Bolton versus Jones. Then cross offer. When two parties exchange identical offers with each other in ignorance to each other's offer, we say that they are making a cross offer. And just because they are exchanging identical offers does not mean that the offer has been accepted. Then we have understood what is a counter offer. Counter offer is when a condition is put forth the original offer, and as soon as this condition is put forth the original offer lapses. Then we have understood what is a standing, open or continuing offer. So this is an offer which is made to public at large but which is open for a specified time period, which continues for a specified time period. After this, we have also understood what are the essential elements to be present in a valid offer. So offer, it must be capable of creating legal relationship. The terms in the offer must be certain, definite and not vague. Offer must be communicated to the offeree, and the case law here was Lalman Shukla versus Gauri Dutt. The offer must be made with an intention to obtain the assent of the parties. It may be conditional. Offer must not contain any such term where non-compliance of that term would lead to acceptance of the offer. So there shouldn't be any such term in an offer which is being made. Offer may either be general or specific, it may be express or implied, and statement of price is not an offer. And there is a difference between offer and invitation to offer, offer and communication of information, offer and statement of intention, prospectus, advertisement, etc. So there is a difference between offer and all these things. And we have also seen some case laws here. One was Harvey versus Pacey, then Harris versus Nickerson. So these were some of the case laws which we have understood with respect to this particular point. After this, we have understood what is an invitation to offer. An invitation to offer is circulation of offer with an intention to induce people to make an offer, to induce offer, to call for offers from different people. And after this, we have understood what is acceptance. So acceptance is nothing but when a person gives his assent to the offer which has been made. We say that the offer is accepted. And what is the relationship between offer and acceptance? The relationship between offer and acceptance is similar to a train of gunpowder and a lighted matchstick. And after this, we have also understood what are the legal rules regarding valid acceptance. The first rule here was acceptance can be given only by the person to whom the offer is made. So only the person to whom the offer is made has the right to accept the offer. And again here we can use the case of Bolton versus Jones. The next essential element was acceptance must be absolute and unqualified. Absolute means complete and it should not be a conditional acceptance. And case law which we've seen here was Neil versus Merritt. There we have understood that acceptance which is being given should be complete and should not be a conditional acceptance. After this, we have also understood that acceptance must be communicated. Communication of acceptance is as important as communication of offer. And the case law which we have understood here was Brogden versus Metropolitan Railway Company. After this, we have understood that acceptance must be given in a prescribed mode. If there is a mode which has been prescribed, then the acceptance has to be given in that mode only. And regarding time of acceptance, if there is a specified time period in the offer, then the acceptance has to be given within that time period. Or if there is no specified time period, then within a reasonable time. After this, we have also understood that mere silence does not amount to, if someone's keeping quiet, that doesn't mean that he has accepted your offer. And the case law which we've seen here is Feldhaus versus Bindley. And finally, we have understood that acceptance also can be implied by conduct of the parties. So this was with respect to acceptance. After acceptance, we started with communication of offer and acceptance. When do we say communication of offer is complete? When the offeree comes to know about it. So communication of offer is complete when the offeree comes to know about it. And when is the communication of acceptance complete? So communication of acceptance is complete from the point of view of the offerer or the proposer when the offeree puts the letter into the course of transmission. And from the point of view of offerer or proposer, when the acceptor puts the letter into the course of transmission. And from the point of view of the acceptor, the communication is complete when the offerer comes to know about it. So this was regarding communication of offer and acceptance. In certain situations, certain special conditions are tacitly communicated and are tacitly accepted. We've seen two case laws here. One was Mukul Datta versus Indian Airlines and the other was Lily White versus R. Manuswamy. In both the case laws, we have understood that in certain situations, some conditions, some special conditions are tacitly communicated and are also tacitly accepted. After this, we have understood when is communication of revocation complete and till what time an offer or acceptance can be revoked. An offer can be revoked before it is accepted, and acceptance can be revoked by the acceptor till the time the offerer comes to know about the acceptance, or rather acceptance can be revoked until the communication of acceptance is complete from the point of view of the acceptor. And about communication of revocation, the person who is revoking, the communication of revocation is complete from his perspective when he puts the revocation letter into the course of transmission. And the person against whom the revocation is done, the communication of revocation is complete from his perspective when he comes to know about the revocation. English law does not revocation of acceptance, but in Indian law we do have provisions regarding revocation of acceptance. And after this we have understood what are the modes of revocation of offer, where we have understood that offer may be revoked by giving a notice of revocation, or by lapse of time, by non-fulfillment of any conditions which are attached to the offer, by death or insanity of the offerer, by counter offer, by subsequent illegality of the offer, or when it is not given in a prescribed or usual mode. These are different modes of revocation of offer. With this, we have also summarized the entire Unit 1 of the Indian Contract Act 1872. Let's now quickly summarize the entire Unit 2. So Unit 2, we started Unit 2 with what is consideration, and there's a Latin maxim for it, which is quid pro quo, which means something in return. And then we've also understood the definition of consideration. Which section defines consideration? 2 clause D. And how does it define consideration? When at the desire of the promisor. What happens? Promisee or any other person. And then what? Has done or abstained from doing, does or abstains from doing, or promises to do or abstain from doing an act. Such act or abstinence or promise is called as consideration. And when analyzing the definition, we have understood that consideration can be an act, that is doing something, or it can be not doing something. It must move at the desire of the promisor. It may move from promisee or any other person, and it may be past, present or future. After this, we have also understood certain legal rules regarding consideration. So the legal rules regarding consideration were that consideration must move at the desire of the promisor. It should be something which happens at the request of the promisor only. And we have also seen a case law here. The case law was Durga Prasad versus Baldev. The next rule was consideration may move from promisee or any other person. So it is not necessary that the performance has to be done only by the promisee. Any other person may also do the performance on behalf of the promisee. And the case law which we have seen here was Chinnaya versus Ramaya. The next element was consideration can either be executed or executory. Executed when the performance of consideration has been done. Executory when the performance is pending. So consideration can either be executed or executory in nature. Then we have understood that consideration can be past, present or future. So consideration can be a past consideration, present consideration or a future consideration. After this, we have understood that consideration need not be adequate. Adequacy of consideration is not important. It should be something which has certain value in eyes of law. But if it is a situation where the consent of the party is not free and the consideration is shockingly inadequate, then in that case the contract will not be a valid contract. But otherwise, just because the consideration is inadequate, we cannot say that the contract is not a valid contract. Then we have also understood that performance of an existing duty will not amount to consideration. The performance of something which a person is legally bound to do will not amount to consideration. And then we have also understood that consideration must be real and it should not be illusory. It should be something which is real and has value in the eyes of law. And finally, we have understood that consideration should not be immoral, opposed to public policy and unlawful. After this, we have understood a very important doctrine, and that is doctrine of privity of contract, which says that a stranger to contract cannot sue. A person who is not a party to the contract does not have a right to enforce the contract. The concept of stranger to consideration is valid, but stranger to contract does not have any right in the contract. But there are certain exceptions to this doctrine of privity of contract. And then we've also understood all the exceptions. The first exception was in case of a trust. Who gets the right here? The beneficiary of the trust gets a right to enforce the contract which was made between the trustee and the settlor. Then the second situation was in case of family settlement. In case of family settlement arrangements or family settlement contracts, if a family member was not originally a party to the contract, he also can sue upon the contract. Remember the example of Rishi? A few examples to understand that how a stranger can sue in this situation. The next exception to the doctrine of privity of contract is in case of marriage contracts. So in case of certain marriage contracts, when the contract is made for the benefit of a third person or of a stranger, the stranger can sue upon the contract as a beneficiary. The next situation is in case of assignment of benefits to the contract. So whenever the benefits of the contract have been assigned to an assignee, that assignee can enforce his rights on the contract. And we have also understood that only and only benefits can be assigned. There can be no assignment of liability. After this, we have understood that in case of acknowledgement and estoppel as well, stranger to the contract can sue. And in the situation when there are certain covenants running with the land, then all the successive buyers of the land will also be bound by the covenants or the conditions which were imposed by the previous owner. And finally, in case of contracts of agency, when the agent works in his authority and on behalf of the principal, in name of the principal is bound by the agent's contract, and the principal can also sue upon the contract though he is a stranger to the contract. And after this, we have understood a very important rule which said that no consideration, no contract. This is given in section 25 of the Indian Contract Act. And it says that consideration is an integral part of contract, and if there is no consideration, no contract will come into existence. But there are certain exceptions to this rule of no consideration, no contract. So the exceptions to this rule, no consideration, no contract, the first exception is in case of natural love and affection. This exception is given by section 25 subsection 1. And here there are 4 conditions which have to be complied with. 1. The parties to the contract should be in a very close relationship. 2. There must be natural love and affection existing between the parties to the contract. 3. The agreement must be in writing. And 4. The written agreement must be registered under law. If all these 4 conditions are satisfied, then the contract which is made on the basis of natural love and affection, which is written and registered under law, will be valid even without consideration. The second exception is in case of compensation for past voluntary services. So when a person promises to compensate for services which were provided to him voluntarily in past, then in that situation he will be bound by the promise even though there is no consideration. 4 conditions here, we have seen 4 conditions here as well. First condition was the services which are rendered must be voluntary services. The second condition was the services must be rendered for the promisor. The third condition was promisor must be in existence when the services were provided. And the fourth one was that the promisor must intend to compensate for the services. The promisor must have an intention to compensate for the voluntary services which were provided to him. So this was the second exception, and this second exception is given in section 25 subsection 2 of the Indian Contract Act 1872. Then we have seen the third exception, and that was promise to pay time barred debts. 25 subsection 3 talks about promise to pay time barred debts, and here we have understood that if the debt is time barred and there is a promise to pay a time barred debt which is in writing and signed by the debtor or his agent, then that promise will be valid even without consideration. This promise could be for full payment of debt or part payment of the debt. So again, in this situation, without consideration as well, the contract will be a valid contract. The next exception is in case of agencies. So consideration is not necessary in case of agency contracts. There may be consideration or there may not be consideration. It is not mandatory for a consideration to be present in case of a contract of agency. Then we have understood that in case of completed gifts, they are valid even without consideration. So a gift which is given by a donor to the and accepted by the donee will be valid even without consideration. The next exception was in case of bailment. Bailment is where the possession of goods is transferred from the bailer to the bailee for a particular purpose, and the goods have to be returned back to the bailer or his order once the purpose is over. So in case of contracts of bailment, also consideration is not mandatory. There may be consideration or there may not be any consideration. Contracts of bailment are valid even without consideration. And then finally we have understood that in case of charity, again the contract is valid without consideration. If a person has incurred some liability on the basis of a promise which was made to him, then in that situation the promisee is bound by the promise and cannot step back. He is liable to pay the amount whatever he has promised. Whatever he has promised to pay, though he is not receiving any benefit, though he is not receiving any consideration. Charity is also an exception to the rule no consideration, no contract. With this, we have also summarized the entire Unit 2. Let's now quickly summarize Unit 3. So in Unit 3, we have discussed 4 essential elements of valid contract in detail. We started with the essential element with capacity to contract. So a person is competent to contract if he has attained the age of majority, he is a person of sound mind, and he is not disqualified by law. Now this age of majority is prescribed by the Indian Majority Act, and the age which has been prescribed is 18 years. And in this, we have also understood the rules regarding a minor's position in an agreement. An agreement which is made by a minor is void ab initio. We have also seen a case law here, Mohri Bibi versus Dharmodas Ghosh. Minor cannot ratify a contract on attaining majority. So minor cannot make the contract enforceable after he has attained the age of majority. Minor can always plead his minority. Minor can be a beneficiary of the contract. A minor can definitely become a beneficiary of the contract. A minor's estate is liable for all the necessaries which are provided to the minor. So if a person provides any necessities to the minor, his estate will be liable to that to reimburse the amount to which the person has incurred in providing necessities to the minor to the person. Then parent or guardian can enter into a contract with a minor, but only if it is for the benefit of the minor. We've also understood that a minor cannot be asked to specifically perform whatever he has promised to perform. A minor cannot become a partner, he can only be admitted to the benefits of the firm. Minor cannot be declared as an insolvent person. Minor can definitely act as an agent of another person. Minor cannot bind his parents or guardians unless and until he is acting as their agent. If a major and a minor together enter into a contract, then in that situation, the third party can enforce the contract against the major. If someone has provided surety for the minor, then the contract will be assumed to be a direct contract between the surety and the third party. We have also understood that a minor cannot become a shareholder, and minor is liable in case of torts. Tort means a civil wrong or a wrongful act. So these were the rules regarding a minor's position in an agreement, which we have understood. Then we have understood who is a person of sound mind. Section 12 tells us who is a person of sound mind, and section 12 tells us that a person who is in a position to understand the terms of the contract and make rational judgment is a person of sound mind. Two important things: understanding the terms of contract and making a rational judgment, is able to take a decision. Then we have understood who is a person disqualified by law. So insolvents, convicts, criminals, foreign ambassadors, alien enemies, these are some of the persons who are disqualified by law from entering into contract. After this, we have started with the second essential element, and that was free consent. Section 13 talks about consent means agreeing upon the same thing in the same sense. Latin maxim, consensus ad idem. Consent is not free if it is caused by any of these means. What is coercion? Section 15 talks about coercion. This committing an act forbidden by IPC, threatening to commit an act forbidden by IPC, unlawful detaining of property or threatening to detain someone else's property with an intention to make that other person enter into a contract. Coercion can move from a stranger and can be done upon a stranger. Burden of proof in case of coercion is on the aggrieved party. Then we started with undue influence. Section 16 talks about undue influence. What is undue influence? When one person is in a position to dominate the will of the other person and uses his dominant position to make the other person enter into a contract and takes unfair advantage of this other person, in that situation we say that undue influence has been used, and burden of proof in case of undue influence is on the person who is in a dominant position. After this, in section 17, we have understood what is fraud. So, false statement made by a person who knows about its falsity, active concealment of facts, making a promise without intention of performing, or any other act which is done with an intention to deceive the other person will amount to fraud. What will be the effect of fraud? The aggrieved party can either resign the contract, sue the other party for damages, or ask the other party to perform whatever he had promised to perform. And will mere silence amount to fraud? No, mere silence does not amount to fraud, but there are two exceptions to it. One, when it is the duty of the person to speak. What are the 5 situations when it is duty of the person to speak? In case of fiduciary relationship, in case of contracts of insurance, contracts of marriage, contracts of family settlement, and share allotment contracts. In all these 5 situations, it is the duty of the person to speak, and if the person keeps quiet, then it will amount to fraud. And the second exception is when silence is equivalent to speech. So when silence is equivalent to speech, in that situation, silence will amount to fraud. After this, we have understood section 18, which talks about misrepresentation. So in case of misrepresentation, what happens? A false statement is made by a person who believes the statement to be true, or it can be breach of duty without any intention to deceive. So in those situations, we say that misrepresentation has happened. And then we have understood what are the effects of coercion, undue influence, fraud, and misrepresentation. What are the effects? The contract is voidable and can be avoided by the aggrieved party. But if a person has not been actually misled by the fraud and misrepresentation, then in that situation he cannot avoid the contract. Or if the person by ordinary diligence would come to know about the actual facts, then in that situation as well he cannot avoid the contract. Then we have understood what is mistake. Mistake can be mistake of law or mistake of fact. Mistake of law can again be divided into mistake of Indian law or mistake of foreign law. In case of mistake of Indian law, it cannot be used as an excuse. Ignoratio juris non executor. In case of mistake of foreign law, mistake of foreign law shall be treated as mistake of fact. Mistake of fact can be further divided into two categories, bilateral mistake and unilateral mistake. Bilateral mistake is where both the parties are mistaken regarding a fact which is essential to the subject matter of the contract. In that situation, the contract will be a void contract. But in case of unilateral mistake, the contract will not be a void contract just because one person is mistaken regarding certain facts. But yes, there are two situations when in case of unilateral mistake as well, the contract will be void. One is where the person is mistaken regarding nature of the contract. The second is when one person is mistaken regarding the identities of parties to the contract. After mistake, we have started with the third part, and that was legality of object and consideration. So the object and consideration are lawful unless they are forbidden by law, defeat any provisions of law, are fraudulent in nature, causes injury to a person or property of another person, are immoral in nature, or are opposed to public policy. And in what situations we say agreements are opposed to public policy? When there is an agreement which is made for trading with enemy, stifling of prosecution, maintenance and champerty, trafficking in public offices, interference with the course of justice, agreements creating monopolies, marriage brokerage agreements, when agreements create interest against obligation, or when the consideration is unlawful in part. In all these situations, we say that these are agreements which are opposed to public policy. And after this, we have started with void agreements. What are void agreements? The agreements which are not enforceable. And in what situations are the agreements void? When made by incompetent parties, made under bilateral mistake of fact, when the consideration or the object is unlawful, or when the consideration or the object is partly unlawful, or when there is an agreement made without any consideration, agreement in restraint of marriage restricting a person from getting married except a minor is void. In restraint of trade, subject to certain exceptions in case of sale of goodwill, partnership act, trade combination, service agreements, etc. Agreements in restraint of legal proceedings, if a person is restricted from enforcing his legal rights under a contract, then in that situation such an agreement will be void. But if the parties, they have specifically decided upon to submit their dispute to arbitration, then in that situation the contract will be a valid contract. And if there is an agreement which is made, the meaning of which is not certain, in that situation again the agreement will be a void agreement. And finally, in case of wagering transactions, what are wagering transactions? A promise to pay money or money's worth, and this promise is based on condition of happening or non-happening of an uncertain event. There must be two parties who are in a position to win or lose. There must be a common intention of betting when the agreement was made, and the only interest which the parties have in the agreement is the stake and no other. They do not have any interest in the outcome of the event. These type of agreements are wagering agreements, and they are void and unenforceable in nature. What are the transactions similar to wagering? Lottery transactions, crossword puzzles which come in newspapers, speculative transactions, horse race transactions. These are some of the transactions which are similar to wager. And in case of horse race transactions, they are considered as wagering transaction if the prize money is less than 500. If it is 500 or more than that, then the transaction will be a valid transaction. And what are the transactions which resemble wager but are valid? Chit funds, games of skill or athletic competitions. Games of skill are not wager provided the prize money does not exceed ₹1000. And share market transactions or commercial transactions are also resembling wager but are valid transactions. And finally, contracts of insurance, they resemble wager but they are valid transaction. And after this, we have also understood what are the differences between insurance and wagering transaction. And finally, the last situation where an agreement is void is in case an agreement is impossible to perform, or when an agreement is made to do something which is impossible. So when there is no possibility of performance at all, the agreement will be a void agreement. With this, we have also summarized the entire Unit 3. let's quickly summarize the entire Unit 4. We started Unit 4 with the obligations of parties to the contract, and there we have understood the obligation of the parties to the contract is to either perform the contract or make an offer to perform the contract. So performance can either be actual performance or attempted performance. Attempted performance is also called as offer of performance or tender of performance. What is attempted performance? Attempted performance is where one person is willing to perform his part of the promise and also goes forward with the performance, but the other person refuses to accept the performance. That type of performance is an attempted performance. After this, we have also understood that who are the people who can perform the contract. It is the promisor who has to do the performance, and if it is a contract which involves personal skill or intelligence of the promisor, then the contract comes to an end on the death of the promisor. In such type of contracts can be performed only and only by the promisor himself. Apart from the promisor, agent also can perform the contract provided the contracts are not based on any personal foundation. Apart from the agent, legal representatives of the promisor may also perform the contract. Legal representatives, in case of the death of the promisor, it is the legal representative who will have to make the performance. And if the contract is based on personal skill and intelligence, then in that case, as soon as the promisor dies, the contract also comes to an end. And legal representatives are bound to perform only to the extent of the property which they have inherited from the promisor. And apart from this, we have also understood that in certain situations, some third party makes the performance and this performance of third party is accepted. So when the promisee is accepting the performance of promise by a third party, then he cannot later on enforce the contract against the promisor. So if the performance of third party is accepted, then the same contract cannot be enforced against the promisor. And then we have also understood that in case of joint promisors, all the promisors are jointly liable to perform their respective promises. After this, we have understood that what will be the effect of refusal to accept performance. In a situation where one party to the contract has made an offer to perform, but the other party does not accept the performance, then in that situation, the promisor will not be blamed for non-performance. The promisor will not be held liable for non-performance and he will not lose any rights under the contract. But three conditions to be satisfied in this case. One is the performance should be unconditional. Second is it should be made at a proper place and a proper time. And the third condition is that the other person should be given a reasonable opportunity to check that whatever performance is happening is as per the contract which is made. After this, we have understood that what will happen when the promisee refuses to perform. So in this situation, the promisor has two rights. He can either terminate the contract or continue the contract. If he decides to continue the contract, then later on he cannot terminate the contract on the same grounds. And whether the contract is terminated or whether it is continued, in both the situations, the promisor can claim compensation from the promisee. So whether contract is terminated or continued, compensation can be claimed in both the situations. After this, we have understood what are the liabilities of joint promisors. So who are joint promisors? When two or more persons together make a promise. In case of joint promisors, all the joint promisors are jointly liable. In case of death of a joint promisor, his legal representative along the other surviving joint promisors will become liable. So the legal representatives of joint promisors are also bound by the promise. We have also understood that in case of joint promisors, any one joint promisor may be compelled by the promisee to make the performance. Just because one of the joint promisor is compelled to make the performance does not mean that the liability of the other joint promisors towards the person who has been compelled comes to an end. The other joint promisors will definitely have to give their share of the contribution to the joint promisor who was compelled to make the payment. And what will happen in a case where one of the joint promisor makes a default? Then whatever is his share will be divided equally amongst the other joint promisors. And similarly, the promisee may also release one of the joint promisor. And just because the promisor has been released, his liability towards the promisee comes to an end. But his liability towards the other joint promisor does not come to an end. He has to contribute, he has to give his share of contribution to the other joint promisors. Then we have understood who are joint promisees. The joint promisees are entitled to receive performance. They are entitled to claim the performance. And in case of death of a joint promisee, his legal representatives can demand the performance of promise from the promisor. After this, we have discussed what shall be the time and place of performance. Section 46 to section 50 deal with time and place of performance, where we have understood that if no time has been fixed and no application is required, the performance has to be made within reasonable time. Second situation was where time has been fixed and no application is required, then the performance shall be made during usual business hours. When application is required by the promisee, then it is the promisee's responsibility to make the application and fix a proper place and a proper time for performance of promise. What if the place is not fixed and application is not required? Then in that situation, it is the promisor's duty to contact the promisee and ask the promisee to fix a proper place for performance of the promise. And finally, section 50 says that whichever manner is sanctioned by the promisee, the performance has to happen in that manner. And after this, we started with performance of reciprocal promises, where we have discussed section 51 to 58. 51 talks about simultaneous performance. It says that if a person is not bound to perform his part of the promise unless and until the other party is also willing to perform his part of the promise. So there has to be simultaneous performance of promises. Section 52 talks about order of performance. In certain situations where the order is fixed by the contract, then the performance has to be made in that order only. And if no order has been fixed but the nature of transaction is such that order plays an important role, then in that case the order will be determined by the nature of transaction. 53 talks about liability of a person who is preventing the other person from performing the promise. So in a case when one party prevents the other party from performance, then the contract becomes voidable at the option of the other party, and the other party is also entitled to receive compensation from the party who has prevented him. Then section 54 talks about dependent reciprocal promises. So where the performance of reciprocal promise is dependent on act which is done by a party, and that party does not perform the act, then the other person is not liable for performance unless and until the dependent promise is performed, and this person is also entitled to receive compensation from the other party. In section 55, we have understood the importance of time. If time is essential, then contract can be avoided and compensation can be claimed. If time is not essential, contract cannot be avoided but compensation can be claimed. If time was essential but the performance is accepted even beyond the specified time limit, then in that situation compensation cannot be claimed unless and until a notice of intention to claim compensation is given at the time of acceptance of performance. Then we have understood section 56, where we discussed agreements which are impossible to perform. So an agreement to do something impossible is void. Impossibility can either be initial impossibility or supervening impossibility. Initial impossibility, which is existing since the time the contract has been made, and supervening impossibility is an impossibility which occurs due to change in law, change in circumstances, or happening of an event. Supervening impossibilities are also called as subsequent impossibility or post-contractual impossibility. So here, in case of supervening impossibility, the contract was previously valid, but later on, due to change in the circumstances or happening of an event, now that the performance is impossible, the contract becomes void. Then we have understood that if reciprocal promises are do something which is legal and illegal, then only the part which is legal will be valid and enforceable, and the illegal part will be void and not enforceable. Section 58 talks about alternate promises are made where one part is legal and the other part is illegal, then only the legal part is enforceable and not the illegal part. After this, we have understood provisions regarding appropriation of payments. Section 59 to 61 talk about appropriation of payment. 59 tells us that if the debtor has indicated the debt against which the payment has to be appropriated, then the appropriation has to be done in that manner. Section 60 tells that if the debtor has not indicated anything, then the creditor, as per his discretion, can make the appropriation. And 61 says when neither the debtor nor the creditor has made any appropriation, then in that case the appropriation has to be made in the order of time. And if two debts are of equal standing, then the appropriation has to be made proportionately. After this, we started with contracts which need not be performed with consent of both the parties, where we started with section 62, where we have understood what is novation, rescission and alteration. In all these three situations, by mutual agreement, the original contract is discharged, it need not be performed. Then section 63 talks about remission, where there is a waiver of whole or part performance. 64 talks about restoration of benefit which have been transferred under a voidable contract. If a contract is voidable and it is rescinded by the aggrieved party, then if the aggrieved party had received any benefit under the contract, they will have to return it back to the person from whom they received it. Section 65 is also on the same lines, but this talks about restoration of benefits received under a void contract. So if any benefits were transferred to a person under a void contract, the person who has received the benefit is liable to return it or is bound to return it back to the person from whom he has received it. Section 66 talks about communication of rescission. Communication of rescission should happen in the same manner as communication of offer, and revocation of rescission also has to happen in the same manner as revocation of offer. And then in section 67, we have understood that in case the promisee does not provide reasonable facilities to the promisor, then the promisor is excused of his performance because of want of reasonable facilities. And after this, we have discussed discharge of contract. What are the ways in which a contract is discharged? So there can be discharge by performance, by mutual agreement, by impossibility of performance, by lapse of time, by operation of law, by breach of contract. Section 63, that is remission. Section 67, that is non-provisioning of reasonable facilities, and in case of merger of rights. With this, we have summarized entire unit 4. Let's now quickly revise the entire unit 5. We started unit 5, breach of contract, wherein we've understood that breach means failure to perform the promise, and this breach can either be anticipatory breach of contract or actual breach of contract. What is anticipatory breach of contract? It is the breach which occurs before the date of performance. It is a breach which occurs before the date of performance of promise. Anticipatory breach can either be expressed by words spoken or written, or it can be implied by conduct of one of the parties. And in case of anticipatory breach of contract, the aggrieved party has got two options. One is he can either immediately resign the contract. The second is he can wait till the date of performance. he can consider the contract still operative and wait till the date of performance before he resigns the contract. So these are the two options which are available with a person in case of anticipatory breach of contract. Then we've understood what is actual breach of contract. So actual breach of contract is a breach which occurs on the date of performance, that is on the scheduled date. And actual breach of contract can either happen at the time of performance, that is on the date of performance before the performance is started, or it may also happen during the performance of the contract. So actual breach is one which happens either on the date of performance or it may happen during the performance of the contract. And after understanding what is anticipatory and actual breach of contract, we then started with the remedies for breach of contract. The first remedy is suit for damages, and here we have understood section 73, where we have understood that a person who suffers because of the other party breaking the contract, he is entitled to receive compensation for any loss which naturally arises as a result of such breach. And yes, he is not entitled to any remote or indirect losses, only the losses which naturally arises as a result of breach. The aggrieved party is entitled to recover that as compensation from the party who has committed the breach of contract. Now when we talk of damages, damages are of 6 types. The first type of damage is an ordinary damage. An ordinary damage is a damage which naturally arises as a result of breach. So it is the damage which naturally arises, which directly arises as a result of breach. The second type of damage is a special damage. In order to claim special damages, the aggrieved party shall beforehand make the other person know about certain special circumstances which exist which might affect the contract. So special damages can be claimed only in a situation where a notice of these special circumstances has been given to the other party. When the other party knows about the existence of special circumstances, only in that situation special damages can be claimed. The next damage is vindictive or exemplary damage. There are only 2 situations where these damages can be claimed. The first situation is breach of promise to marry, and the second situation is wrongful dishonor of a customer's check by a banker. In these 2 situations, vindictive or exemplary damages may be claimed. The next type of damage is a nominal damage. Nominal damage means what? There is no actual damage which has happened, but in order to punish the person who has committed breach of contract, the courts may award a nominal amount as damage, and nominal damage can be as less as 1 rupee as well. So that was nominal damage. After this, the next type of damage which we have understood is damage caused due to deterioration by delay. So when there is a damage to the quality of the goods because of the delay which has happened, in that situation as well, damages can be claimed, and for claiming these damages, no special notice has to be given, no special information has to be communicated in order to claim these type of damages. And the next type of damage are prefixed damages. So as the name itself suggests, they are fixed at the time when the contract was made. These are the damages which are fixed at the time of formation of the contract, and the courts can never allow an amount higher than the prefixed amount as damage. Even if the actual loss is more than the amount which has been fixed as prefixed damages, only the amount which has been fixed as the prefixed damages will be allowed. But if the actual loss is less than the amount of prefixed damages, then the courts may order to pay the lesser amount and not the amount of prefixed damages. So these were all the 6 types of damages which we have understood. And after this, we have understood section 74, where we discussed what are liquidated damages and what is penalty. Liquidated damages are a genuine pre-estimate of the loss which may arise in case of breach of contract. Whereas for penalty, there is no particular calculation which is done. It is not a pre-estimate, it is not logically calculated. Rather, it is an unreasonable amount which is far in excess of the probable damage. It is included in the contract in order to force the other person to perform the contract. English law creates a distinction between liquidated damages and penalty, but there is no such distinction made by Indian law. As in Indian law, it is the courts who decide what shall be the reasonable amount of compensation which shall be awarded for the loss which has happened. So it is the courts who will decide. Courts can never allow any amount which is higher than the amount which has been fixed in the contract, but yes, they can definitely allow a lesser amount as compensation. So this was with respect to liquidated damages and penalty. After this, we have understood the second remedy, which is suit for rescission. Rescission means cancellation of the contract. So when one party breaks the contract, the other party has a right to rescind the contract and claim compensation for any loss which they would have suffered. The next remedy was suit upon quantum merit. Quantum merit means as much as is earned or according to the quantity of work done. Suit upon quantum merit basically allows the person who has made a part performance to receive money for the performance which he has done. It is according to how much a person deserves. What are the situations where suit upon quantum merit can be filed? One, where the contract is discovered to be void or it becomes void due to happening of an event. Second situation is when any act is done with any non-gratuitous purpose. The third situation is when there is an express or implied contract but there is no agreement regarding remuneration. The fourth situation is where one party refuses to perform the contract, commits breach of contract. The next is when the contract is divisible and the other party, that is the party who is not at fault, has enjoyed certain benefits of the contract. And finally, in case of indivisibility of contract, when the contract is indivisible but it has been completely performed but in a bad way, then in that situation, the lump sum amount as consideration has to be paid to the person after reduction of any amount for the bad job which has been done. So these are all the situations wherein suit upon quantum merit may be filed. The next remedy is suit for specific performance. So when damages are not adequate remedy, in that situation the party can file a suit for specific performance and the courts will compel the party committing the breach of contract to actually perform whatever he has promised to perform. And the last remedy is suit for injunction, wherein a person has promised not to do something, then the courts may issue injunction orders stopping him from doing something which he has promised not to do. So these were all the remedies which we discussed, and finally we discussed one small section, section 75, where we have understood that when a party rightfully resigns the contract, he is entitled to receive compensation due to non-fulfillment of the promise. So with this, we have now summarized the entire Unit 5. Let's now move ahead to Unit 6. Unit 6 talks about contingent and quasi-contracts. We started with contingent contracts. What are contingent contracts? They are contracts to do or not to do something if some event collateral to such contract does or does not happen. What are the essential elements of a contingent contract? 1. The performance depends on happening or non-happening of an event. The event is a collateral event. It is not the part of the contract and it is neither performance of promise nor any consideration. The third essential element was that the event must not be mere will of the promisor. And the fourth essential point was that the event must be an uncertain event. So these were 4 essential points regarding a contingent contract. After this, we have understood what are the rules regarding enforcement of contingent contracts, wherein we have discussed section 32 to section 36. Section 32 talks about contracts contingent on happening of an event, When are these valid and enforceable? When the event happens. But if the event becomes impossible, the contract also becomes void. Section 33 talks about contracts contingent on non-happening of an event. If the contract is contingent on non-happening of an event, then if the event happens, then the contract becomes void and unenforceable. But if the event does not happen, then or becomes impossible, then the contract is valid. Section 34 talks about contracts which are contingent on an act of a living person, and if this living person does an act which makes the event impossible, then the contract ceases to be enforceable. Section 35 talks about 2 points. One, where the contract is contingent on happening of an event within specified time. If the contract is contingent on happening of an event within specified time, then in such a case, if the event happens within the specified time, the contract is valid and enforceable. But if the time lapses or the event becomes impossible, the contract becomes void. The second part was Section 35 also talks about contracts contingent on non-happening of an event within specified time. So if the contracts are contingent on non-happening of an event within specified time, and if the event happens within that time, then the contract becomes void. But if the event becomes impossible or the time lapses, then the contract is valid and enforceable. And finally, Section 36 talks about contracts which are dependent on happening of an impossible event. So these contracts are always void and are never valid. After this, we have discussed what are the differences between contingent contracts and wagering agreements, wherein we have understood that contingent contracts are valid whereas wagering agreements are void. Contingent contracts are contracts to do or not to do something if an event happens or does not happen, whereas wagering agreements are promised to pay money or money's worth, wherein money plays an important role in case of wagering agreements. In case of contingent contracts, the uncertain event is a collateral event, whereas in case of wagering agreements, the uncertain event is the core factor of the contract. In case of contingent contracts, the parties are interested in the subject matter, whereas in wagering agreements, the parties are not interested in the subject matter of contract. In wagering agreements, both the parties are in a position to win or lose. But in case of contingent contracts, there is no probability of win or lose of both the parties when we talk of contingent contracts. Contingent contracts may not be wagering in nature, but wagering agreements are essentially contingent in nature. So this is one very important difference on which a question can also be asked. And after this, we started with quasi-contracts. Quasi-contracts are not actual contract, but they resemble a contract. A law imposes certain obligations on a person and gives right to a particular person, wherein in fact there is no actual contract between them, but law has imposed certain obligations on them. Those type of contracts are quasi-contracts. These contracts are made with an intention to prevent unjust enrichment, which they work on the maxim, no one should grow rich on another person's loss, or no person should grow rich on another person's money. So this is the main formula for quasi-contracts. Quasi-contracts, there are certain cases which are deemed to be quasi-contracts. Section 68, which talks about claim for necessaries provided to incapable persons. This section says that if a person is providing necessaries which are essential for survival of an incapable person, then this person is entitled to receive reimbursement of the amount which he has spent on provision of necessaries. But in order to establish his claim, he'll have to prove 2 points. One, that the person to whom he has provided necessaries is an incapable person. Two, that the supplies which he has made is of actual necessaries which are essential for this incapable person's survival. only then he'll be able to claim the reimbursement. And reimbursement out of what? Reimbursement out of the property of this incapable person. Then we have understood that in section 69 that if an interested person makes payment on behalf of another person who was actually bound by law to make the payment, then he is entitled to receive the reimbursement from the other person. Section 70 talks about obligations of parties who have enjoyed benefits of a non-gratuitous act. So, if a person who has lawfully received the delivery of goods or has done any lawful act, but this act was done with a non-gratuitous purpose without any intention of doing gratuitously, and the other person for whom the act has been done has enjoyed certain benefits, then this other person is bound to compensate the first person or to restore the goods which he has received from the first person. So, the example of Swiggy and Amazon fit very well for this particular section. What are the three conditions to be satisfied here? 1. Has received the delivery lawfully. 2. The act has been done non-gratuitously. 3. The other person has enjoyed the benefit of such act or delivery. So, if all these three conditions are satisfied, then the person who has enjoyed the benefit is bound to compensate the other person or return the goods or restore the goods back to the other person. And in section 71, we have understood that the responsibility of finder of goods is just like a bailee. He has to take proper care of the goods. He does not have a right to use the goods. No appropriation of goods can be done. And he has to restore the goods or return the goods back to the true owner when the true owner is found. So, these are the rights and responsibilities of a finder of goods. And then finally in section 72, we have understood that if a person receives money by mistake or under coercion, then he is bound to return it back to the person from whom he received it. So, money paid by mistake or under coercion, then the person who has received it is bound to repay or return it. Then we have understood two small differences between quasi-contracts and a contract. So, here in case of quasi-contracts, all the essential elements are not present, whereas in case of contract, essential elements are present. In case of quasi-contract, the obligation is imposed by law, whereas in case of contract, the obligation is not imposed by law, but rather the parties themselves decide what are their contracts or what are their obligations on the basis of their contract. So, with this, we have now summarized the Unit 6. Now that we have finished the Indian Contract Act, it's time for us to start with the second act, and that is Sale of Goods Act 1930. But before we go to the Sale of Goods Act, few important points regarding Indian Contract Act 1872, and that is this act forms a base for all the other acts which we are going to study. Contract Act forms base for the Sale of Goods Act as well as the Partnership Act. Also, Contract Act plays a very important role in the day-to-day transactions as well, which we happen to do. A Contract Act is an act from which you will get majority questions in your exam. And it is also one of the most interesting and easiest topics. And what are the things we've studied in the Contract Act? We've studied what is a contract, essential elements of contract, types of contracts, offer, acceptance, performance of offer, acceptance, communication of offer and acceptance, revocation of offer and acceptance, what is consideration, what are the essential elements in detail, who are competent to contract, what is free consent, what are the agreements which are void, what is lawful object and lawful consideration. We have also understood provisions regarding performance of contract, who is bound to make performance, liabilities of joint promisors, time and place for performance, performance of reciprocal promises. Then we have also understood what are the situations where contract need not be performed with consent of both the parties, discharge of contract, breach of contract, two types: actual, anticipatory, remedies for breach of contract, 5 remedies: suit for damages, suit for rescission, quantum merit, specific performance, injunction, and then we've studied what are contingent contracts and quasi contracts in detail. So these were all the things which we've studied in the entire Indian Contract Act, and all these things cover your section 1 to section 75 of the Indian Contract Act 1872. And the remaining part of the Indian Contract Act, that is regarding special contracts, you will study at your CA intermediate level.